Can you challenge a protective order in Indiana? The simple answer is yes. If a petitioner files a protective order in Indiana, a judge has one of two options. They can either grant that protective order without a hearing, which is called an ex parte order of protection, or two, the judge could set the matter for a hearing. Now, no matter what situation happens if you are being served with protective order, you certainly can challenge it and fight it in court. If you're given a protective order that has already been granted, then what you need to do is file a demand for a hearing within 30 days of that protective order going into effect. If you do not file a demand for a hearing within that 30 days, you can give up your right to have a hearing on that protective order. Now, the second option is having the judge set a hearing from the onset. Now, if that happens, you'll be given a subpoena in the mail to attend a hearing. If you do not show up for that hearing, more than likely, the judge is going to grant that protective order. Now, in any situation, it's always important to have an attorney, because when you go to a protective order hearing, even though it's civil and not criminal, it acts like a criminal trial. And what I mean by that is the petitioner will have to put on evidence, and it's on them to prove the allegations in the protective order, not beyond a reasonable doubt, but beyond a preponderance of evidence, meaning more likely than not. During these hearings, the petitioner has to lay out their groundworks for why they believe they should be granted an order of protection. They're allowed to call witnesses, testify themselves, and present evidence. Now, that's why having an attorney is very important. You want an attorney to be able to analyze everything they're saying, listen to the evidence that's presented, cross-examine any witnesses, cross-examine the petitioner if they testify, and also present evidence on your own behalf. You never want to get into a situation where you're defending yourself in a protective order hearing for a variety of reasons. The most important being, if you go in there on your own, you're basically giving up your right to remain silent. If you try to argue this protective order on your own, and there's a criminal investigation going on in conjunction with this protective order, then the state could use what you say in this protective order hearing against you if any charges were to be filed based on what the petitioner is alleging in the order of protection. Another reason why it's important to have an attorney with you while fighting a protective order is because of the negative consequences that can come if that protective order is granted. Now, because this is a civil matter and not a criminal matter, even if that protective order is granted, you're not going to go to jail. However, many times it's going to limit you from having contact with someone. Now, if that someone is an ex-significant other that you share a child in common with, that's going to lead to issues as far as dealing with the child. Additionally, if a protective order is granted, you can lose your right to firearms. And then if you're found later with firearms, you can be charged criminally for having a firearm in violation of that protective order. Lastly, even though this is only a civil matter, when that order of protection is entered, if there's any violation of that protective order going forward, that's going to be a criminal charge called invasion of privacy. Invasion of privacy is a Class A misdemeanor in Indiana that can carry up to 1 year in jail and a fine of up to $5,000. If you have any questions about protective orders, or if you've been served with a protective order yourself, I know this can be scary, but please give us at the Marc Lopez Law Firm a phone call, 317-632-3642. And remember, always plead the fifth.